Okay, this is file 25-22492-FH, People of the State of Michigan versus Michael Gene Walters. We are here today for a pretrial conference in this case and proceeding today by video conference. Can I have the attorneys place their appearances on the record?
Ashley Messer for the people, Your Honor.
Your Honor, Mark Kohler on behalf of Mr. Walters, who's appearing by Zoom as well.
And sir, you are Michael Gene Walters, correct?
Yes, sir.
Okay, Mr. Kohler, where do we stand with Mr. Walters' case today?
I have submitted over 1,000 pages of medical documentation, Your Honor, to the Attorney General's office. I'm not sure what else they need for us to substantiate the affirmative defense, but if they're not willing to dismiss the case, and I suggest that we set it for a bench trial in front of you and we proceed. Showing up every few months to wait for an answer of what we're doing is probably getting tiresome for us and also for the court.
All right, Ms. Messer, do you know where things stand on the people's side?
Yes, Your Honor. I do see a note here from Ms. Brenner that medical paperwork was received. It looks like the last time we were here in June, there was some issue with the warrant outstanding and adjournment was requested so that the original paperwork could go over by Ms. Brenner. At this point, Your Honor, I see no notes indicating that we are submitting a nollie-pros for this case, so I believe setting this for a trial is appropriate.
Do you know if the bench warrant was lifted?
I do not have any notes to that effect.
We request somebody check because my client's been arrested once already. He's already posted bond. He's paid additional child support. To have a warrant hanging over his head at this point as we keep on appearing in court would be unjust at best.
All right, I presume that a one-day trial is a sufficient amount of time?
Yes, Your
Yes,
Honor.
Judge.
All right, Ms. And I'm sorry, Ms. Messer, are the people in agreement with a bench trial as opposed to jury trial?
Yes, Your Honor.
Okay, so Ms. Clark, can you find us a one-day date for a bench trial, please?
Thursday, October 22nd at 9 a.m.
Sounds like an excellent day.
Just if I could just check Ms. Brenner's calendar.
Yeah. And in the meantime, I can try to get hold of Miss Brenner again.
That looks like a good date for us, Your Honor. Thank you so much.
Okay, so I'm going to set it for a trial date of October 22nd at 9 a.m. and a final pretrial on October 14th at 8:15 a.m.
Will the final pretrial be in person, Your Honor?
No, that can be done by Zoom.
Excellent.
Trial date obviously needs to be in person. I will prepare and send out a scheduling order that has those dates in it.
Thank you, Your Honor.
Okay, anything else we need to address with that case today?
Not from the people, Your Honor. Thank you.
Not from us either, Your Honor, but thank you.
All right, thank you. Mr. Walters, you can go ahead and log out.
All right, thank you.
Have a blessed day, everybody.
Thank you. Okay, Ms. Underwood, are you ready to proceed with Mr. Bowker?
I believe we are, Your Honor.
All right. This is file 24-21719-FH, People versus James Thomas Bowker. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Ashley Messer for the people, Your Honor.
Rhonda Underwood for Mr. Bowker this morning, Your Honor.
And sir, you are James Thomas Bowker.
James Bowker, yes, Your Honor.
Ms. Underwood, where do we stand with Mr. Bowker's case?
I believe we're prepared at this point to enter a plea to a 90-day child support disorderly on this matter, Your Honor. I don't know if an amended complaint has been issued. Someone from the AG's office, I believe, sent me an encrypted thing this morning that I could not open. And I think that might be what it is, but I'm just suspecting. And I don't know if Mr. Bowker has submitted a advice of rights, so we may have to put this off till a day when that can be done as well, Your Honor.
Okay, I don't see either an amended information or a signed advice of rights form. Oh, I do have an amended information that was just handed to me, but I do not have a signed advice of rights form. And so we are going to have to adjourn this to another date when I do have a signed advice of rights form. I would also note that fingerprints for this case are still outstanding. Court entered an order for fingerprints back on October 30th of 2024. And at last check, we still did not have fingerprint information for Mr. Bowker. So we need to get both of those things done. I will adjourn this to August 19th at 8:15 a.m.
Your Honor, since Mr. Bowker is going to be pleading to a misdemeanor, do we still need fingerprints?
As far as I know, yes.
Okay. And that date again, Your Honor?
August 19th at 8:15 a.m.
And I will do the stip order with Ms. Messer's permission.
Yes, please. Thank you, Ms. Underwood.
Okay. So Mr. Bowker, your next date will be August 19th at 8:15 a.m.
All right, thank you, Your Honor.
Great, so you can go ahead and log out. Ms. Underwood, do you need to speak to Stephen Johnson?
Yes, please.
Who was here in person?
Mark Klein.
Okay, Ms. Beach, are you ready to proceed with Mr. Klein?
Yes, Your Honor.
Mr. Johnson, I'm going to put you in a breakout session with Ms. Underwood. You're going to need to unmute your device. Okay, this is file 25-22426-FH, People of the State of Michigan versus Mark Klein. We are here today for a pretrial conference in this case, and we are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. McClure.
Good morning, Phoebe McClure, on behalf of the people, filling in for prosecutor of record, Mr. Sneed.
Good morning, Your Honor. Christine Beecher here on behalf of the defendant, Mr. Mark Klein, who is present to my left in the courtroom this morning.
And Ms. Beecher, where do we stand with Mr. Klein's case today?
Your Honor, Mr. Klein will be entering a plea today to added count 2 failure to return rental property, $200 to $1,000. And that was with the sentence agreement of no immediate jail due to his health. And also they will not charge unlawful driving away of an automobile and shall dismiss the count 1.
Okay, Ms. McClure, is that a complete and accurate statement of the agreement?
It is, Your Honor.
Has an amended information been prepared? I don't have one.
I do see one in the file. Let me go ahead and forward that to your office.
Okay. Thank you.
And then I have the signed plea agreement and vice of rights. Do you have that?
Yes, I do have those, are both in the file. Mr. Klein, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury? Yes. Go ahead. Can you hear me? And you, sir, are Mark Klein, is that correct? Mr. Klein, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to the added count 2 on the amended information, which is failure to return rental property in the amount of $200 to $1,000? Yeah. Do you understand that the maximum possible penalty for that offense is up to 1 year in jail? Are you satisfied with Ms. Beecher and the advice that she's given? Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been stated on the record here this morning. Is that correct, Ms. McClure?
That is correct.
Ms. Beecher?
Yes, Your Honor.
Is that also your understanding, Mr. Klein? If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Klein, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right. If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you? And do you understand that you're giving those rights up? How do you wish to plead then to the charge that on or about May 29, 2025 in Adrian Township, Lenawee County, Michigan, that you did commit the offense of failing to return rental property valued at $200 to $1,000? I'm sorry? If you want to plead guilty, you would need to say guilty. Has anyone made any threats or promises to you to induce you to plead guilty to that charge? Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea? Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Klein to plead guilty today?
No, Your Honor.
No, Your Honor.
Sir Klein, other than as it's been stated on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be? If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes but is not limited to absconding or failing to appear at sentencing, violating bond conditions, violating the terms or conditions of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that? Is it your own choice to plead guilty today? Ms. Beecher, would you like to establish factual basis?
Yes, Your Honor. Mark, on May 29th of 2025, were you in the county of Lenawee, state of Michigan? And on that day, did you have some rental property from Penske in your possession that you failed to return? And would it be accurate to state that that rental property had a value of $200 to $1,000? I believe that's sufficient, Your Honor.
Ms. McClure, are the people satisfied?
I would have some follow-up questions, but I can't hear the defendant's answers. So I guess if the court can just let me know how he answers.
Okay, so I'll just repeat them then.
Okay, thank you. Was the rental property rented from Lock It Up Storage on US 223 in Adrian Township?
You indicated yes.
And were you supposed to return it on May 4th, 2025 to that location?
You said yes.
And in fact, you were in possession of it when you were confronted by the police later that month. Is that correct?
You said yes.
Okay, people are satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Ms. Beecher?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Klein has had full knowledge of his rights and he has had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've stated it on the record here today. I will refer this matter to the probation department. That will be the district court probation office. And we can set sentencing for August 20th at 8:15 a.m. Mr. Klein, you will need to report to Mike McCarron in the district court probation office on the first floor this coming Tuesday at 8 a.m. All right, anything else we need to address with this case today?
No, Your Honor.
No, Your Honor.
All right, thank you then. We're all set. We'll see you back here for the sentencing date. Okay, Ms. Underwood, are you ready to proceed with Mr. Johnson?
Yes, Your Honor, thank you.
Okay, this is file 24-21757-FH People versus Stephen Jermaine Johnson. We are here today for a hearing on a probation violation related to payment of child support, and we are proceeding today by video conference. And I first have the attorneys place their appearances on the record.
Ashley Messer for the people.
Rhonda Underwood for Mr. Johnson this morning. Your Honor. Thank you.
And Ms. Underwood, where do we stand with Mr. Johnson today?
Mr. Johnson has appeared this morning, Your Honor. He has had some setbacks this month. He had to get a new apartment with the children, who are now in his custody. And, we would ask, Your Honor, just for a brief adjournment to allow that to stabilize so Mr. Johnson can continue getting funding into the child support, Your Honor. At this point, he's had to use those funds for other things.
Ms. Messer, are the people in agreement with an adjournment?
Yes, Your Honor, I would just note that Mr. Johnson has made some payments, although they are minimal compared to what his support obligation was ordered at the time. I am in agreement with an adjournment because he has made some payment efforts.
Okay. All right, I'm going to adjourn this then to September 2nd at 8:15.
Thank you, Your Honor.
And is a stipulation in order necessary on a violation of probation, Your Honor?
No, we'll send out a notice on that.
Thank you, Your Honor.
Thank you.
So Mr. Johnson, your next date is September 2nd at 8:15. You can log in using all the same Zoom information that you used to log in today.
Yes, I'm sorry, Your Honor. I didn't hear that last part regarding violation.
All we've done today is just adjourn your hearing until the next date. There's been no other decisions made.
Okay, thank you, Your Honor.
Right. All right, so you can go ahead and log out then. Ms. Underwood, are you going to need to speak to Ryan Olson?
No, I don't believe so, Your Honor.
Okay, this is file 26-22579-FH People versus Ryan Lee Olson. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Ashley Messer for the people.
Rhonda Underwood for Mr. Olson this morning, Your Honor. Thank you.
And Ms. Underwood, where do we stand with Mr. Olson's case today?
Mr. Olson had some problems with his veterans benefits, Your Honor. Those should be reinstated later this week. I discussed with the AG's office possibly a 30-day adjournment just to make sure we're back on track, Your Honor. I would hope that would be agreeable.
Ms. Messer, are the people in agreement with an adjournment?
Yes, Your Honor. As I would note, the defendant did pay above and beyond his monthly obligation in February, March, April, and May, and he did make a small payment in the month of July. So I can see sort of why the benefits fell off, and that corresponds to maybe why the payments fell off. So as I understand, the defendant maybe have those benefits reinstated and be able to get back on track. So those are the reasons that people are in agreement with an adjournment.
Okay, so I'll adjourn this one to September 2nd at 8:15 a.m. Mr. Olson, you'll be able to log in using all the same Zoom information that you used to log in today.
Yes, Your Honor. Thank you.
And I will do the stip and adjournment with Ms. Messer's permission.
Yes, thank you, Ms. Underwood.
Okay, so Mr. Olson, you're all set. You can go ahead and log out.
Thank you, Your Honor.
Okay, I have a jail device that is logged in. The camera is off and the microphone is muted. I'm going to send you a request to start the video. And a request to unmute your device. And you are Mr. Harris, correct?
Yes, sir.
Ms. Beecher, do you need to speak to Mr. Harris?
No, Your Honor.
Okay. This is file 25-22314-FH, 25-22371-FH, and 25-22474-FH. People versus Dewan Pfeiffer Harris. We are here today for pretrial conferences in each of those cases, and we are proceeding today partially in person and partially by video conference.
Your Honor, is Mr. Hartung on?
He is not. Do we need him for this case?
It is his. Let me look at the notes.
So Phoebe, I did speak with him this morning. He's in the courtroom next door. So I was just going to, I think we have the one file scheduled for trial and the other two adjourned.
Okay, I can cover that then.
Okay.
Okay, so Ms. McClure, do you want to place your appearance on the record?
Yes, sorry about that. Phoebe McClure, on behalf of the people.
Good morning, Your Honor. May it please the court, Christine Beecher on behalf of the defendant, Dewan Pfeiffer Harris.
And sir, you are Dewan Pfeiffer Harris, correct?
Yes, sir.
Okay, and so we have the 25-22314 file set for trial beginning November 30th. We'd also set today as a pre-trial date. There's also a final pre-trial date set for November 18th in that file. So Ms. Beecher, is there anything we need to address today?
In this file, Your Honor, I would just ask the opportunity to address bond.
All right, Ms. McClure, are you going to be in a position to address bond, or are we going to need Mr. Hartung for that?
Yeah, I'm not familiar enough to. I can just reflect what procedurally what's happened as far as bond, but factually, I'm not familiar enough to speak to that.
All right, I think we should pass this then until we have Mr. Hartung. I know we've had a number of bond discussions in this case previously, and I think it would be appropriate for him to be present for that.
I can send him a message and let him know that you want to address it.
All right, Mr. Amadeo, are you ready to proceed with Mr. Pinkelman?
Your Honor, I think he had to
Yeah,
I think he had to pop over to Judge Anzalone's courtroom. He said
Okay.
he'd be right back though.
Mr. Castleberry, are you ready to proceed with Ms. Gray?
I am, Your Honor.
All right, this is file 26-22660-FH, People versus Kelly Teresa Gray. We are here today for a pretrial conference and proceeding today by video conference. First, going to have the attorneys place their appearances on the record.
Alex Bayonetta for the people.
Bert Castleberry on behalf of Miss Gray.
And Mr. Castleberry, where do we stand with Ms. Gray's case today?
Your Honor, we have secured this afternoon appointment with your office for a Cobb's evaluation at 3 o'clock. We are asking for a short adjournment to accomplish that evaluation, and I think we will be able to resolve this via plea bargain.
Okay, Mr. Bayonetto, anything that you need to address at this point?
No, Your Honor.
Let's go with August 13th, or August 19th. August 19th at 8:15 a.m. And Mr. Castleberry, could you prepare a stipulation in order for that adjournment?
I will, Your Honor. Thank you.
Okay, if there's nothing else we need to address in this case, you can go ahead and log out.
Thank you, Judge.
All right, so we're back on the record in file 25-22314-FH, 25-22371-FH, and 25-22474-FH, People versus DeJuan Pfeiffer Harris. We do have Mr. Hartung here now. Mr. Hartung, would you like to place your appearance on the record?
Yes, thank you, Your Honor. Good morning, Doug Hartung, attorney for the people today.
All right, and so I previously indicated we have a scheduling order in place and the trial set for the 25-22314 file. And Ms. Feature wanted to address Mr. Harris's bond. So Ms. Feature, you can go ahead and do that.
Thank you, Your Honor. Mr. Harris currently has 3 open files. This bond is set at $110,000. He's been incarcerated for a significant amount of time. I would ask that you allow him to get out on a reasonable cash surety bond, possibly in the $10,000 range, and have him wear a tether pending his trial.
Mr. Hartung.
Your Honor, the only thing that I'm aware of that is new since the last time we discussed this issue in particular is that Mr. Millar is no longer on the case. We went through this in some detail, and if the court recalls, it was the court who suggested we set the trial date because the court was well aware of the situation with its schedule. And had the court not stepped in to set the trial date when it's set, and it's still set down the road a ways, this would have been just a pretrial to set a trial today. But the court saw that the problem was advancing and set the trial date. I think that's the end of November, beginning of December, something in that range. But there's nothing new. We went through this in great detail a couple of times previously with Mr. Millar representing the defendant. And the court is aware that there's 3 separate cases, each involved in the sale of narcotics. Each had a preliminary examination. Each of those cases were bound over for trial. No motion to quash has ever been filed. The most recent of those cases occurred while the defendant was out on bond. And not only did it trigger a contempt charge, it also triggered my discussion about the fact that the case with the fentanyl and carfentanil, very serious drugs, has an extremely low bond. And that was one reason why the court set the bond as it did on the contempt and on the contempt charge and on the, I think on the 3rd charge as well, the bond is relatively high. So I'm aware of nothing new since our last discussion on this, other than the fact that Mr. Millar was no longer on the case.
All right, as I previously indicated, the court has stated its reasons for setting Mr. Harris's bond where it is. I think in light of the information before the court that that bond is reasonable and appropriate, given the fact that, again, while on bond, he did receive new charges for activity that is alleged to have occurred while he is on bond. That case was, did have a case was bound over for trial, and that case, in addition to additional delivery or manufacture charges, includes now weapons charges in the newest case. And so I have concerns about his activity while out on bond, and I think that bond is appropriately set where it is, and so I would deny the request to modify.
Thank you, Your Honor.
Thank you. Mr. Harris, you can let the officer that's with you know that you're done with work for today.
Okay.
Ms. Underwood, do you need to speak to Mr. Cherry?
No, I do not, Your Honor.
Feature, I have Mr. Liebman logged in. Are you going to need to speak to him?
No, I don't, Your Honor. Are we finished with Mr. Harris? Are we going to set new pretrial dates for the other two cases that are not proceeding to trial?
You know what? I'll just set those unless you want something different for the same date as the final pretrial date.
Okay, thank
That
you.
works. Thank you for that reminder. Okay, and I'm sorry, did you say you needed to speak to Mr. Liebman or not?
No, Your Honor.
Mr. Cherry.
Would that be 11?
So this is file 22-20683-FH People versus Paul Edward Cherry. We are here today for a hearing on an alleged probation violation and proceeding by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Cherry this morning, Your Honor. This is a violation of probation, Your Honor.
Yeah. Mr. Cherry, I'm sending you a request to unmute your device.
Okay, are we good now?
You are Paul Edward Cherry?
Yes, sir.
Okay, Ms. Underwood, where do we stand with Mr. Cherry's case today?
Yes, Your Honor. Mr. Cherry did have a hearing in bankruptcy court last week, and his next hearing date there is scheduled for 9/10 at 10 a.m. So we would ask for an adjournment till after that date, Your Honor.
All right, what I'll do then is adjourn this to September 23rd at 8:15 a.m.
Thank you, Your Honor.
So, Mr. Cherry, your next date, September 23rd. You can log in using all the same Zoom information that you used today.
Yes, sir. Thank you.
Okay. Okay, Mr. Liebman, I just sent you a request to turn on your camera, and then I'm going to send you a request to unmute your device.
Okay. There we are.
This is file 26-22544-FH and 26-22545-FH, People versus Joseph Tyler Liebman. We are here today for a pretrial conference in both of those cases, and we are proceeding today by video conference, partially by video conference, partially in person. First, can I have the attorneys place their appearances on the record?
Phoebe McClure, on behalf of the people.
Morning, Your Honor. Christine Beecher here on behalf of defendant Joseph Tyler Liebman.
And sir, you are Joseph Tyler Liebman.
Yes.
Ms. Beecher, where do we stand with Mr. Liebman's cases?
Your Honor, I would just ask for an adjournment on these cases, just to give us an opportunity to discuss further.
Okay, Ms. McClure, are the people in agreement with an adjournment?
We have no objection. And just for the record, last time we were here, we were waiting on the exam transcript. It looks like we do have that now.
Okay. All right, I will adjourn this then until September 2nd at 8:15 a.m. for both cases.
Thank you, Your Honor.
And Ms. Beecher, would you do a stipulation in order for each file?
Yeah. Do I have your permission to sign?
Yes.
Thank you.
Okay, so Mr. Lehman, your next date is September 2nd at 8:15 a.m. You can log in using all the same Zoom information that you used today.
Thank you, sir.
Thank you. Okay, Mr. Amadeo, are you ready to proceed with Mr. Pinkelman?
Good morning, Your Honor. Yes, we're ready to proceed.
Okay.
Thank you. Yeah. Thank you.
This is file 25-22212-FH, People versus Brent Stephen Pinkelman. We are here today for a final pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto?
Alex Bayoneto for the people.
Good morning, Your Honor. William Amadeo, P76194, on behalf of Brent Pinkelman. We have consent to this hearing via Zoom. Brent, please state your name for the court.
Brent Stephen Pinkelman.
Okay.
All right, and Mr. Amadeo, where do we stand with this case today?
Your Honor, we are set for a jury trial on August 4th. Mr. Bayoneto and I have stipulated the jury instructions. We present our witness list and voir dire questions. I'll turn to the people judge, but I think we're prepared to proceed.
All right, Mr. Bayoneto.
That's correct, Your Honor. There was maybe just a slight oversight in the case. There wasn't a scheduling order in this case, so I did not have my voir dire instructions done. I didn't realize Mr. Amadeo had submitted his, but I will get those to him and to the court by the end of the day today. Outside of that, all of my witnesses have been subpoenaed and spoken to. Everybody will be there, so we should be good to go for Tuesday.
All right, so trial will commence then on Tuesday, August 4th at 9 a.m. I don't know if anyone has electronic exhibits are going to be displaying on the television, but I always recommend that you stop in beforehand and make sure that everything works, because our system is temperamental.
Yes, Your Honor. I guess there's only one other thing. Mr. Amadeo and I had spoken about this yesterday. He had provided a witness list to the court with an additional witness. When we spoke yesterday, we agreed that that witness would be stricken from the witness list, and the stipulated witness and exhibit list that was filed with the court will be the final witness list for both parties.
That's an accurate statement, Your Honor. And if Mr. Bayoneto does need to take any witnesses off, we've been in constant communication, Your Honor. All the discoveries and all the witnesses have been shared. We're both on the same page with everything.
Okay. All right, we will see you then on Tuesday, August 4th at 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Mr. Rocket, do you need to speak to Javon Smith?
Yes, Your Honor, I do.
Okay. Mr. Noe, are you ready to proceed with Mr. Maples?
Yes, if I can speak to him briefly beforehand, though.
All right, 1 second. Sir, ma'am, do you have a case that you're here for?
Our son, Caleb Rao.
Okay. You call the jail and see if second.
Can you take a second? We have Caleb Rowell. Please. Caleb Rowell, R-O-W-E-L-L. Great, thank you. Bye.
I have someone here screaming as Tishan Williamson. Can you tell me what case you're here for?
Judge, I can speak to that. She's here on the Maples case. She's
Oh, okay.
a victim in that case.
Okay, thank you. This is file 26-22661-FH, People of the State of Michigan versus Javon Lavelle Smith. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, I have the attorneys place their appearances on the record. Looks like Mr. Sneed's case. Is someone covering for Mr. Sneed?
I can cover that, Your Honor.
Okay.
Alex Bayanetto for the people.
Dylan Rockhead on behalf of Mr. Smith.
Okay, and Mr. Rockett, where do we stand with Mr. Smith's case today?
Your Honor, I do have a plea agreement. I can send that over shortly. And then Mr. Smith did allow me to sign with his permission both the plea agreement and the advice of rights.
Okay, and so do you want to state the terms of the plea agreement then?
So Mr. Smith would be pleading guilty to count 1, and the people have no objection to sentencing under the Holmes Youthful Training Act, and they will also dismiss count 2 of the uttering and publishing.
Mr. Bayanetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
Okay, Mr. Smith, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Javon Lavelle Smith?
Yes.
You can put your hand down if you'd like, Mr. Smith. Mr. Smith, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, uttering and publishing?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 14 years in prison?
Yes.
Are you satisfied with Mr. Rockett and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been discussed on the record here today. Is that correct, Mr. Bayanetto?
Correct, Your Honor.
Mr. Rockett?
Yes, Your Honor.
Is that also your understanding, Mr. Smith?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them, okay?
Okay.
You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Smith, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about November 2, 2025 through November 6, 2025, that you did commit the offense of uttering and publishing?
One more time.
How do you plead to the charge that on or about November 2nd, 2025 through November 6th, 2025 in Clinton Township, Lenawee County, Michigan, that you did commit the offense of uttering and publishing?
Pleading guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Smith to plead guilty today?
Correct, Your Honor.
Correct.
Are you aware of any promises, threats, or inducements other than the plea bargain?
Sorry, Your Honor, no.
No, Your Honor.
Okay. Has your attorney, Mr. Smith, promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court is not bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. You understand that, Mr. Smith?
Yes.
Is it your own choice to plead guilty?
Yes.
Mr. Rocket, would you like to establish the factual basis?
Yes, Your Honor. Mr. Smith, on or about the dates between November 2nd and November 6th, were you at a Dollar General store in Clinton, which is in the town or the county of Lenawee?
Yes.
And did you have in your possession some $100 bills that were discovered to be counterfeit?
Yes.
And did you try to pass off those bills as legal tender?
Yes.
Okay. Does that satisfy the court, Your Honor?
Mr. Van Netto, are the people satisfied?
Mr. Smith, you knew those bills were counterfeit when you tried to pass them as real, correct?
Yes.
And it was your intent to pass those bills in order to receive items from Dollar General with the fake money?
Yes.
Okay, I'm satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Van Netto?
It has, Your Honor.
Mr. Rocket?
Yes, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Smith has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 3rd at 8:15 a.m. Mr. Smith, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
And I'm going to place you in a breakout session with Ms. Walsh from the probation office so that she can collect the contact information and tell you what you're going to need to do next.
Judge,
Okay.
I don't need to do that. He needs to come to our office today and pick up the PSI paperwork.
Okay, so Mr. Smith, you need to come to the Lenawee County Circuit Court Probation Office and pick up that paperwork today.
What's the address again?
Address of the courthouse is 425 North Main Street. And that is in Adrian, Michigan.
Okay.
And the probation department is on the 3rd floor.
Okay.
Okay, so you're all set for today then.
All right, thank you.
Okay, I have a device logged in as jail Zoom 4, and I am sending a request to start the video on that device. And I'm sending a request to start the audio. And Ms. Underwood, do you need a breakout session with Mr. Roll?
I don't believe I do, Your Honor.
All right. This is file 23-21406-FH and 23-21497-FH. People versus Caleb Emmanuel Roll. And we are here today for a hearing on a probation violation in each of those cases. We are proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Rowell today, Your Honor.
And sir, you are Caleb Emmanuel Rowell?
Yes, sir.
All right, Ms. Underwood, where do we stand with Mr. Rowell's case today?
Well, Your Honor, it's kind of confusing, but Mr. Rowell was on probation on this case and 2 cases in Ohio, Your Honor. In 2024, Mr. Rowell failed to report on those cases. He was picked up in Ohio in 2024, July or August. I don't know the exact date. He was picked up in Lucas County and has been ever since then in various prisons serving out his sentences in Ohio and trying to get Michigan to address this issue, but it has not been. I would respectfully ask that there's been no new crime committed since he was put on probation. He was on probation for these things when he went on probation for ours. I would respectfully ask that perhaps the probation department consider letting Mr. Rowell off with time served, Your Honor, in this matter. I believe that would be appropriate. He has been continuously incarcerated for 2 years at this point.
That's not the information that we have, Judge. He was sentenced with us, subsequently absconded, and had new charges after he was sentenced on our probation for 2 counts of felony burglary and 2 misdemeanors, obstructing justice. And he was sentenced on those 18 of 24. We would ask that he remain.
Well, the only thing you've charged him with in terms of violation of probation is the failure to report.
Wait, right. He was just arrested. We didn't know that he had the new offenses until this arrest. Because he had absconded. We didn't know where he was.
Mr. Rowell, I thought you, never mind.
Can I say no?
Do you want to speak to him in a breakout session, Ms. Underwood?
Yeah, just briefly.
All right, we have Ms. Underwood, Mr. Roll back from the breakout session. So Ms. Underwood, where do we stand?
Your Honor, I would simply state that I believe Mr. Rao has served all the time he would normally serve on these issues, Your Honor. I see his mother is in the courtroom.
Ms. Underwood, I'm just going to interrupt. I need to know whether he wants to plea or whether he wants to set this for a hearing.
Mr. Rao, are you going to plead to failure to report?
Yes, I am.
Okay.
Miss Underwood, it's likely there will be some added violations for the new charges.
Then perhaps we should wait until we have all of them. If the probation department is going to do that.
Judge, we just found out about this yesterday, and Miss Holly, everybody's in training today except for me. So she will take care of those added conditions ASAP. He did plead to new charges and was sentenced.
I wasn't.
Your Honor, I'm going to ask you possibly address bond in this
Does he want to
issue.
set it for, I'm sorry?
I'm going to ask to possibly address bond in this issue.
I take that to mean you're asking for an adjournment at this point?
Yes.
All right, I'm going to adjourn this to next week, August 5th at 8:15 a.m.
Thank you, Your Honor.
What would you like to say about bond, Ms. Underwood?
Thank you, Your Honor. Your Honor, Mr. Rao is a resident of Lucas County. His mother is here today, Your Honor. I assume that was who he would be residing with. At this point, Mr. Rao wants nothing more than to resolve these issues. He's resolved every issue he has in Ohio. He no longer has any time to serve there. I believe, in light of the circumstances, that at this point, a PR bond is appropriate in this matter, Your Honor. Especially with the situation that if he does fail to report, that just gets him in more deep water. And Mr. Rao has been digging himself out, Your Honor.
Judge, obviously we would object to the reasons that he absconded and he wants to go to Ohio. We have to submit a whole new transfer for something like that, which takes time.
Your Honor,
Well, he was living in Ohio his address has been Ohio the whole time.
Right, but since he was absconded, our transfer is no longer good. We have to resubmit everything. And he would have to report here.
Cannot speak.
No, Mr. Rowley, you're represented by an attorney.
Okay.
All right, obviously, this is a unique situation. There doesn't appear to be much dispute that Mr. Rowell failed to report back in January 24. And during that intervening period, he was apparently arrested and convicted of some new criminal charges. Acknowledge that he has served a significant amount of time on those charges, which are likely going to form the basis of a new alleged violation of probation in this case, which is problem that occurs when you engage in these types of behaviors while you're already on probation. These things start to stack up. And the consequences increase. So whether or not there may be additional time for you to serve on these files, Mr. Rall, I don't know at this point, because I don't know exactly what's happened yet, and I don't know how it's going to play out. But at this point, I am willing to issue a PR bond to Mr. Rowell with a GPS tether and the condition that he be on house arrest at his mother's home. And I acknowledge his mother, I believe it's both parents are here in the courtroom. I'm going to ask you to wait in the hall to speak to Darren Coast. He's our pretrial services coordinator. He's going to collect your contact information so that we know where we're monitoring Mr. Rowell from here forward. But that's going to be the decision of the court today.
Thank you, Your Honor.
So we've got the next date. That is next week, August 5th at 8:15 a.m. So, Mr. Rowell, you can let the officer that's with you at the jail know that you're done with court for today.
All right. Thank you, sir.
Do that? Okay.
Okay, Mr. Noe, Ms. Arnold, are you ready to proceed with Mr. Maples?
Yes.
We are, Your Honor.
You call the jail for Dylan Myers. Features Mr. Roberts here. Do you know he's not logged in?
Your Honor, both Mr. Dylan Myers and Mr. Kenneth Roberts are incarcerated at Lenawee County Jail.
That's right. He wasn't on the jail sheet for some reason. Okay, we're calling for Mr. Myers right now.
Thank you.
All right, then. This is file 23-21397-FC. People of the State of Michigan versus Stephen Maples. We are here today for a hearing on the people's motion to compel discovery of an expert report from Dr. Daniel Naiman. And we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Good morning, Your Honor. Charles Noe appearing on behalf of Mr. Maples.
And sir, you are Stephen Maples, correct? Sorry, I was not able to hear you.
I am.
Thank you.
Yes, we're looking for.
Ms. Arnold, this is the people's motion. You can proceed with any argument you have at this point.
Judge, in terms of the motion, I think it's kind of moot at this point, given the court's decision regarding Dr. Naiman. I know Mr. Noe is asking to have Dr. Mayman generally testify about sleep, stress, sleep deprivation, stress, COPD, whatever, affecting the defendant's intent in this case. I don't think I need an expert report on that. I will object at trial if I think it crosses into diminished capacity, but to the effect it might affect intent, I don't believe we'll object. So I guess it's kind of premature to have the court rule on that.
All right, Mr. Noe, anything you would like to say on the issue?
On that particular issue, no. If she's not going to be moving forward with the motion, then I have nothing to respond to.
Okay, then what the court will do then is just treat the motion as moot, given the ruling the court made after the Daubert hearing we had recently. And if issues need to be addressed during trial testimony, we can address them as they arise.
And Judge, there's a couple other issues in terms of the final pretrial. It's my understanding that the defendant is going to assert a defense that his behavior was involuntary because he was either unconscious or asleep at the time the incident took place. I have submitted to the court yesterday a jury instruction. Mr. Noe sent me some language. I tweaked it a little bit. I sent a proposed jury instruction to the court on the voluntariness defense that would be appropriate. Additionally, I did previously submit a memo because I had forgotten an instruction when I did the initial trial packet on on state of mind 16.23. So we need to add that. And I've included a proposed jury instruction on intoxication as a defense to a specific intent crime. It's the position of the people that if the defendant, in the defense, it comes up that the defendant was intoxicated at all in terms of negating any of the intent necessary for a criminal charge, that we'd be entitled to this instruction because it talks about voluntary intoxication and the circumstances under which the court can consider that as being relevant to intent, because there are circumstances where voluntary intoxication cannot be used to negate intent in any way, shape, or form. So we're requesting that instruction if necessary at trial.
Okay. And I'm sorry, you said the state of mind instruction, and that was 16 point what?
That is 16.23. And what I can do is I can email, I sent those previously to the court. So I can email a set to your secretary and Miss McGrain sometime before trial with everything in it, if that might make it easier since they came in 3 separate documents.
Yeah,
and then if Mr. Noe has an objection to the voluntary intoxication instruction, I guess we can address whether it's appropriate or not after the close of defendant's proofs.
Yeah,
if there's not agreement.
Yeah, I received them yesterday. Some couple non-standard jury instructions. Well, one was a jury, one was a standard, was 6.2, and then I received the voluntary act one. For the most part, I think they both make sense, but again, I'm not prepared to concede that fact at this time. On initial review, they do seem relevant and appropriate, but again, that we need to further address that before trial. We can, obviously, especially at before closing instructions.
And then just a couple other things, Judge. In light of the defense that's going to be asserted in this case, and Mr. Noe and I had put a couple evidence stipulations on the record last time. We are amending our witness list. I filed that about 5 or 6 days ago. It strikes some unnecessary witnesses. Mr. Noe and I have had a chance, because it's within the 28-day period, Mr. Noe and I have had a chance to discuss that, and I don't believe he has any objection to us excusing the witnesses per the amended witness list.
I agree.
And then Mr. Noe has not submitted any additional voir dire questions. I would just ask if he has any additional voir dire questions other than those submitted by the people, that he get us a copy so we can see if we object to any of those questions. We've worked really well together, so I don't think that'll be an issue. Also, we are meeting on photographs to try to reach consensus on what photographs come in. There are some there's some body camera footage and some photographs in which the deceased victim, Kathy Maples, private parts are depicted. So we're going to be looking at blocking out some of that stuff. But Mr. Noe and I are going to meet on that, and I don't think that'll be an issue either.
That is correct.
And Judge, I do believe that Mr. Noe wants to address something with his client on the record.
And I guess the other part is, in terms of voir dire, I've checked my system. I don't see where the people sent me any proposed voir dire questions. I don't see that.
They were in the initial trial packet that was sent to Mr. Daly quite a while ago. So I also sent Mr. Daly a stipulation on those, and I believe that stipulation was signed and entered already.
Yeah, if you could send me a
But if
copy,
you-
that'd be very helpful.
We can do that.
Awesome, thank you. I guess based upon that, I didn't have any knowledge of that. Obviously, that was before my representation, but ultimately, the last thing, so if you can send me that, that'd be very helpful. Then I can address that if it need be before trial. And then lastly, I did want to address something with my client that I believe Mr. Arnold wanted addressed in a previous conversation with her. Mr. Maples, I just have a couple questions for you, sir. You want to proceed to jury trial in this matter, just yes or no, is that correct?
That's correct.
And you and I have had a chance to talk about a couple different plea offer opportunities, is that also correct?
Yes.
And one of them is you'll enter a plea of no contest to second degree murder with no sentencing agreement. Is that one of them, as far as you know?
Yes.
And then the other one is a more updated one, relatively very recently. That was a plea offer to second degree murder with a sentencing agreement, was commonly referred to as a Killebrew agreement, for 16 years as the bottom end of the sentencing agreement. Is that also your understanding as well?
Yes.
And you, at this point, you don't want to proceed with either one of those plea offers. Is that also correct?
That's correct.
Okay. All right. That's all I really wanted to address outside with my client. Other than that, I believe we are still set to proceed to trial. And I believe we are set to begin on August 19th. Is that at 10:30, I think? Because I think it's a Wednesday. If I'm wrong, the court can correct me on that.
That's correct. That is correct. And just on voir dire, so everyone's aware, my recent practice has been to have the court ask kind of the standardized questions that are easy to answer by having people raise their hand or not raise their hand so we can get through those quickly, and then allowing each attorney an opportunity to question jurors directly if they want to do that.
Very well.
Sounds good.
Okay, is there anything else we need to address with the case today?
No, thank you, Your Honor.
No, Your Honor, thank you.
Okay, trial will commence then on August 19th at 10:30 a.m. Mr. Maple, if you can let the officer with you know that you're done with court for today.
Yes, sir. Thank you.
Thanks, Judge.
All right, and the gentleman at the jail, you are Mr. Myers?
No, that's Mr. Roberts.
That's Mr. Roberts. Okay. Do you need to speak to him?
No, Your Honor. The court should
Your Honor.
be in a state. Just a moment, Mr. Roberts.
Okay.
Yeah,
If not, I have a hard copy.
Yeah, I've got a plea agreement and signed by Stripes. Okay, this is file 25-22485-FH, 25-22486-FH, and 26-22695-FH. People versus Kenneth Ray Roberts II. We are here today for pretrial conferences in all of those cases. The file ending 486 has a pending contempt of court for a violation of bond conditions and a pending contempt of court for a failure to appear. We are proceeding.
I have that here, Your Honor.
You have what?
I have where I was at Sacred Heart for that failure to
okay.
appear. Yeah.
All right, we'll get to that. So first, let me have the attorneys place their appearances on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Christine Beecher here on behalf of the defendant, Kenneth Ray Roberts II.
Okay, and where are we with Mr. Roberts' case today?
Your Honor, Mr. Roberts will be accepting a plea in file number 25-22485. He will plead to count 2. And in file number 26-22695 FH, he'll plead to count 1. The sentence agreement is no prison time, no Department of Correction time, and the people shall dismiss all the remaining counts and the habitual offender supplements and dismiss file number 25-22486 FH.
Okay, Mr. Bayanetto, is that a complete and accurate statement of the plea agreement?
It is, Your Honor.
All right, Mr. Roberts, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do, Your Honor.
And you are Kenneth Ray Roberts II, is that correct?
I am, Your Honor.
Mr. Roberts, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today in file 25-22485-FH to count 2, receiving and concealing stolen property of $200 to $1,000?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a fine of the greater of $2,000 or 3 times the value of the property?
I do, Your Honor.
Is it your intention in file 26-22695-FH to plead guilty to count 1, possession of methamphetamine?
I do, Your Honor.
You understand that the maximum possible penalty for that offense is up to 10 years in prison and or a fine of $15,000?
Yes, Your Honor.
Are you satisfied with Ms. Beecher and the advice that she's given you?
I am, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed on the record here this morning. Is that correct, Mr.?
Correct, Your Honor.
Ms. Beecher?
Correct, Your Honor.
Is that also your understanding, Mr. Roberts?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Roberts, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
I do, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of the rights I've explained to you?
I don't, Your Honor.
Do you understand that you're giving them up?
I do, Your Honor.
How do you wish to plead then in file 25-22485-FH to the charge that on or about October 21st, 2025, in the city of Adrian, County of Illinois, state of Michigan, that you did commit the offense of receiving and concealing stolen property of $200 to $1,000?
Guilty, Your Honor.
And how do you wish to plead to the charge in file 26-22695-FH that on or about February 21, 2026, in Lenawee County, Michigan, that you did commit the offense of possession of methamphetamine?
Guilty, Your Honor.
Has anybody made any threats or promises to you to induce you to plead?
No, Your Honor.
Do you understand that if I accept your pleas, you'll be giving up any and all claims that your pleas were given as the result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter those pleas?
I do, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Roberts to plead guilty today?
No, Your
No,
Honor.
Your Honor.
Mr. Roberts, has your attorney promised you any particular sentence or estimated what your sentence would be other than as it's been stated on the record this morning?
No, Your Honor.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I do, Your Honor.
Is it your own choice to plead guilty today?
It is, Your Honor.
Ms. Beecher, do you want to establish the factual basis?
Yes, Your Honor. Kenneth?
Yes.
On or about October 21st of 2025, were you in the county of Lenawee, state of Michigan,
I was.
in the city of Adrian?
Yes.
And on that day, when the police executed a search warrant of your house, did they find you to be in possession of some JBL microphones?
Yes.
And those were stolen, or not, you were in possession of them and they were stolen from someone, to the best of your knowledge, correct?
Yes.
Okay. Are the people satisfied for that case?
Mr. Roberts, you knew they were stolen, correct?
Well, I mean, yeah, they were in the back of my truck where he left them. I only assumed that they was.
Okay. But you at least should have known they were stolen.
Yes, yes, yes.
I'm satisfied, Your Honor.
Thank you. And then Kenneth, on or about February 21st of 2026, in the city of Adrian, County of Lenawee, state of Michigan, were you there?
Yes.
And on that day, did you have some police interaction?
Yes.
And when they came to search you, did they find you to be in possession of methamphetamine?
Yes.
And you didn't have any legal right to possess that methamphetamine, correct?
No,
And you knew that substance was methamphetamine?
I did.
I believe that's sufficient, Your Honor.
Mr. Bannon, are the people satisfied with the factual basis?
I am satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bannon?
It has, Your Honor.
Ms. Beecher?
Yes, Your Honor.
Okay, I will accept the pleas. They've been given understandably, voluntarily, and accurately. Mr. Roberts has had full knowledge of his rights and has had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in the case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as what's been stated on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 3rd at 8:15 a.m. Mr. Robert, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Yes, Your Honor.
All right, and so Ms. Beecher, did Mr. Roberts want to address the contempts today?
Yes, Your Honor. Your Honor, he was having some psychological issues. He was in rehab for a time prior to his failure to appear. So I believe at this time, he will enter an admission to the failure to appear. Is that accurate, Mr. Roberts?
Yeah, what date was that, the failure to appear?
Just a second.
All right.
It appears from the notes that I have, Your Honor, that it was on January 28th and 12/22 and 12/23.
Well, Your Honor, I do have this from Sacred Heart. This was a fax sent over from 3/10 2026 to 3/26 of 2026, from where the court had sent me to Sacred Heart Rehab Facility. And from there I went to Port Huron, which was 20 minutes away, to Sober Living. And I spent 3 months out there and came back just on I had got on the wrong medication, and this is why I'm back here now, Your Honor.
Okay, so we had two, it looks like he previously pled guilty to the failure to drug test from back in December. And then failure to appear was January 28th. What date did you say was on that, Mr. Roberts?
I got on here that it's 3/10/2026 to 3/26/2026. That's when the court sentenced me to Sacred Heart.
Okay, your failure to appear is alleged to have occurred on January 28th.
Yeah.
So that date would have been well before that.
Right. That's what I'm trying to understand. Like, if I went out to rehab, wouldn't it got it addressed, or why didn't it get addressed then?
The fact that you went to rehab doesn't mean that you've addressed your court issues. We had a hearing, you didn't want to, we had a hearing where you were willing to admit to the failure to drug test, but apparently you didn't want to admit to the failure to appear, so that remained pending and still needs to be addressed.
Okay, I understand.
So why don't we just adjourn that to the date of sentencing, and I'll make a decision on how we handle that in light of what's going to happen to the
Your
sentence.
Honor, I think there was a little confusion in regards to this case. When client was appearing in court, there was an arrest warrant, but it wasn't addressed by circuit court. So there was a little bit of delay in this last case for Mr. Roberts. So there might have been some confusion in that. I don't, Mr. Roberts, I don't think that you're necessarily not admitting that prior to you going into rehab, you were struggling and you may have failed to appear for a court hearing.
Right. Well, yeah.
And so, Your Honor, I don't think he's wanting to argue the point that he did, but I think he's saying, subsequently he was in residential treatment and it was communicated to Mr. Malero. So, I mean, we can leave that for sentencing to address that further if you prefer. But I would like to address his bond because he has been incarcerated now for a few months.
What would you like to say about bond?
Your Honor, he has struggled significantly with substance abuse and some mental health issues. He completed Sacred Hearts. He was living in sober living. He had some interaction with his medication for his mental health issues. I would just ask that we give him a PR bond or a low cash surety bond to give him the opportunity to address to continue his road to sobriety, but also to attend community mental health to get his medication regulated and stabilized so he can continue his sobriety path, Your Honor.
I am currently in CMH here in Adrian as well, Your Honor.
Okay. Mr. Bayonetto, is there anything you'd like to say with respect to the bond request?
No, Your Honor, I'll defer to the court's discretion. I think the way Mr. Sneed and Ms. Beecher have the guidelines scored is 5 to 23 months. I'm not sure how close he is to that time already, or he might already be above 5 months. So with the agreement to no MDOC time, I'll defer to the court's discretion.
All right, what I will do at this point is
And I signed for weekly drops too, Your Honor, just so you know.
okay. I will at this point issue a PR bond for Mr. Roberts in each file, subject to the terms that he appear at sentencing hearing or any other hearings that the court schedules in this matter, he abide by any judgment entered in the case and surrender to serve any sentence that's imposed, that he not leave the state of Michigan without the permission of the court, did not commit any crime while released, that he immediately notify the court in writing of any change of address or telephone number, that he make reports to Darren Coast and Lenawee Pretrial Services as directed by Mr. Coast. He not use alcohol, marijuana, or any illegal controlled substances. That he participate in a substance abuse testing and monitoring program as directed by Mr. Coast. And that he participate in any specified treatment program for any physical or mental health condition, including substance abuse, particularly looking at completing your CMH requirements with respect to the mental health issue. So that is the bond that will issue at this point.
Thank you, Your Honor. Does he
Thank
need
you, Your
to
Honor.
come to the courthouse and check in with Mr. Darren Cost?
Yeah, so Mr. Roberts, as soon as you're released, you need to come directly over to the courthouse up to the third floor and go into the clerk's office, ask for Mr. Coast, and Mr. Coast will come out and get you set up with what you need to do while you're
Okay.
on operations.
All right.
Okay,
Thank you.
Kenneth.
Judge, we
Thank you.
also
Just
need him to,
remember. Yep, go ahead, Kenneth.
we also need him to come to our office, please.
Okay.
Okay, so probation as well, okay?
Okay. Thank you.
And remember, if you violate bond or failure to appear, they do not have to stand by the plea agreement that you just entered, okay?
I understand.
Okay, thank you.
Thank you.
Okay, I think we have Mr. Myers might be in this other.
No.
Okay, so you are Mr. Myers, correct?
Yes, sir.
Your Honor, if I could have a brief breakout room with Mr. Myers.
Sure.
Thank you.
Mr. Myers, I'm going to put you in a breakout session with your attorney as soon as she gets logged in here, just a minute.
All right. Thank you, Your Honor.
Your Honor, Ms. Dumont had to log off briefly for a sentencing in a different court, but is MDOC here with Mr. Dickerson?
Yeah, I kept meaning to tell her that, but I kept missing her. So no, they are not. So we're just gonna have to set that one for another date.
Okay, I'll let her know. She should be logging back on here momentarily.
Okay. He's in arraignment. So. You want to step out, and make sure she's logged into the right court. I haven't seen her. She's not logged. Who? Ms. Beecher? Just make sure she's logged into this court, not Judge Ansley on accident. Oh, never mind. Never mind. She just popped up. All right, this is file 26-22704-FH, People of the State of Michigan versus Timothy Ronald Dickerson. We are here today for arraignment in this case, and we're proceeding by video conference. First, to have the attorneys place their appearances on the record.
Alex Bayanetto for the people.
Katerina Dumont for Mr. Dickerson.
And record to reflect this was set for hearing this morning at 8:15 a.m. Mr. Dickerson is incarcerated with the Department of Corrections. They are not logged into this Zoom session. They don't have him here in person at the courthouse. So I don't know that there's anything we can do at this point other than adjourn this for another date. So why don't we go with August 19th at 8:15 a.m. if that works for both attorneys.
That works for the people, Your Honor.
That works for me.
Okay, so August 19th at 8:15 a.m. I did notice in reviewing the file, we don't have fingerprint information for Mr. Dickerson, so I am going to issue an order for fingerprints.
Good morning.
All right, anything else we need to address with Mr. Dickerson's case today?
No, Your Honor.
I don't think so, Your Honor, but with the adjournment, I'll have enough time to contact your office for a COBS. We just wanted to see what the potential sentencing would be with regards to the offer.
Okay. All right, hopefully we'll be able to get that all done by the next hearing.
Thank you.
This is file 26-22681-FH and 26-22682-FH. People versus Dylan Damian Myers. We are here today for a pretrial conference in each of those cases, and we're proceeding today partially in person, partially by video conference. First, going to have the attorneys place their appearances on the record.
Alex Bayanetto for the people.
Christine Beecher here on behalf of the defendant Dylan Damian Myers.
And sir, you are Dylan Damian Myers, correct?
Yes, Your Honor.
Okay, Ms. Beecher, where do we stand with Mr. Myers' case?
Your Honor, I'm going to request an adjournment because we haven't made a whole lot of headway in regards to if he was accepted into ET court. I'm not sure if he was actually screened for it because there was, he didn't have contact information available at that time. And I also would like the opportunity to address his bond.
All right, Mr. Bano, are the people in agreement with an adjournment?
Yes, Your Honor.
Okay, let's set it then for August 26th at 8:15 a.m. And Ms. Beecher, what would you like to say about that?
So, Your Honor, Mr. Myers presents with, he's had significant mental health issues. We're trying to get him into ET court. He also has, he had transportation issues. He didn't have a working phone and he failed to appear and was incarcerated. And so during this time, I've seen great improvement in his cognitive ability. I feel that if he were to be allowed to be on bond again, he would be able to continue that mental health treatment more diligently with community mental health by attending services there and keeping his medication stabilized, which has been a bit of a struggle while he's been incarcerated.
Sir Bano.
Your Honor, I have no position as it relates to bond. I'll defer to the court's discretion.
At this time, we'll issue a PR bond for Mr. Myers, subject to the conditions that he appear for any further hearings we have in this case, that he abide by any judgment entered in the case and surrender to serve any sentence imposed by the court, that he not leave the state of Michigan without the permission of the court, that he not commit any crime while released, that he immediately notify the court in writing of any change of address or telephone number, must make reports to Darren Coast in Circuit Court Pretrial Services as directed by Mr. Coast, must not use alcohol, marijuana, or any illegal controlled substance. And he must participate in any specified treatment program for any physical or mental health condition, and primarily meaning that he follow his CMH treatment requirements. So, Mr. Myers, when you're released from the jail, you need to come immediately over to the courthouse, up to the 3rd floor, ask to see Darren Coast, and he will let you know what else you need to do.
Yes, Your Honor. Thank you very much.
All right, anything else we need to address with Mr. Myers this week?
No, Your
No,
Honor.
Your Honor.
Thank you.
All right, Mr. Myers, you can let the officer with you know that you are done with court for today.
All right, thank you, Your Honor. Thank you, Ms. Beecher.
You're welcome.
Your
Check
Your
in
Honor,
with
is that
Dennis
it?
Cosmo, right?
Yep.
Your Honor, is that it for our office?
Yes, we are all set. Thank you.
All right, thank you.
And I think that concludes everything for today. Thank you, Your Honor.
Thank you very much.